appeal, Amoena, and the Commissioners of the Majesty's Revenue and Customs.
Yes, that's right.
My Lady, my Lords, good morning. I appear with my learned friend Mr. Ed Brown on behalf of the appellant Amoena, and my learned friend Mr. Singh appears on behalf of the Revenue. As your Ladyship, your Lordship will have seen, in our respectful submission, the fundamental issue raised by this appeal is whether the Court of Appeal was right to consider itself bound to allow the Revenue's second appeal to the specialist upper tribunal on the basis of what in our submission were in reality findings of fact made by the Court of Justice, and findings of fact that court made arguably outside its competence in the context of a preliminary reference procedure. Of course, that takes place in the wider context of this appeal, which is the correct classification of a mastectomy bra. And you'll forgive me if I use that shorthand as all the tribunals did. It was explained by the first-tier tribunal at paragraph 21, MS 131, that it covers a broader range of operations than just a mastectomy that is being addressed by the mastectomy bra, but it is has proved to be a convenient shorthand, if I may. And the context, of course, therefore, is whether it is either an item of clothing under heading 6212 of the Customs Code, and therefore subject to 6.5% customs duty, or whether it is an item falling within heading 9021 and therefore free from customs duty. Heading 9021 includes appliances which are worn to compensate a defect or disability, and as the upper tribunal held, the issues are whether it is either an accessory to or part of a prosthesis, the breast form, which it is accepted is an artificial part of the body within heading 9021.31, or whether it is itself such an appliance designed to hold the breast form, an artificial part of the body. The findings of fact are perhaps conveniently summarised both in paragraph 5 of the Statement of Facts and Issues and are agreed, and paragraph 5 of the appellant's case. They are identical, save for the fact that paragraph 4.7 of the appellant's case also adds the finding concerning the intended purpose of lessening the psychological impact of having had a mastectomy. The Statement of Fact and Issues...
Is that contentious?
I don't think it is, my lady.
It's not.
There's a physical and a psychological component.
There's a physical and a psychological component, my lady, yes. And of course, the upper tribunal saw no reason to disturb those findings. See the upper tribunal at paragraph 77 and MS 156. And on the basis of those findings of fact, the specialist upper tribunal resolved both these issues in favour of Amoena, the appellant. Can I perhaps start by taking your ladyship, your lordship, to the relevant legislation briefly, if I may? And this is in Regulation 861 of 2010, which is in the Authorities Volume 1, Tab 1, MS 605. Where we see that it's an amending regulation on the tariff and statistical nomenclature and on the common customs tariff. And it sets out in Annex 1 over the page 607, MS 607, Annex 1, the combined nomenclature. And we've included the whole of the index just to give the court a sense of its structure. Section 1, which we will need to look at, includes the general rules, and Part 2 then goes on to look at the schedule of customs duty. And there we're concerned with Section 11 at page 609, textiles and textile articles, and Section 18 at page MS 610, the optical, photographic, cinematographic measuring, checking, precision, medical or surgical instruments and apparatus, etc., parts and accessories thereof. And then looking at, taking this further to the general rules, we see at page MS 613 the general rules on the interpretation of the combined nomenclature, and in particular, paragraph 1, the titles are for reference only. For legal purposes, classification shall be determined according to the terms of the headings and any relative section or chapter notes, and provided such headings or notes do not otherwise require, according to the following provisions. And then can I draw the Court's attention to 3A through to C, when by application of Rule 2B or for any other reason goods are prima facie classifiable under 2 or more headings, classification shall be effected as follows. And then A, the heading which provides a more specific description shall be preferred. B, which isn't relevant here, deals with composite goods. And C, where goods cannot be classified by reference to 3 or B, they shall be classified under the heading which occurs last in numerical order. And then 4, goods which cannot be classified in accordance with those rules shall be classified under headings appropriate to goods to which they are most akin. And then finally, paragraph 6, for legal purposes, classification in the subheadings of a heading shall be determined according to the terms of those subheadings and any related subheading notes and mutatis mutandis to the above rules, on the understanding that only subheadings at the same level are comparable. For the purposes of this rule, relative section and chapter notes also apply, as the context otherwise requires. We then turn over the page at 616 to look at the heading, the notes to chapter 62, which is articles of apparel, clothing, accessories, not knitted or crocheted. And really only need to look at note 2b. This chapter does not cover orthopedic appliances, surgical belts, trusses, or the like, heading 9021, which is why we're not, in fact, concerned with interpreting chapter 62, but why the whole issue is about whether the mastectomy bra is in chapter, is to be classified under 9021. If it is not, then the current classification is correct. And then we see the notes to chapter 90 and chapter 90 itself at MS 626. And we see again the first note being one this chapter does not cover. And I'd just flag up in part because it was an issue below but is no longer an issue. Part 1b, supporting belts or support articles, etc., whose intended effect derives solely from their elasticity. And that was an issue below but was resolved against the revenue both at the first tier and at the upper tier and is no longer in issue. And then we see under M, which is probably paragraph 2, subject to note 1 above, parts and accessories of machine apparatus, instruments or articles of this chapter are to be classified according to the following rules. And then A does not apply to us, but B, other parts and accessories, if suitable for use solely or principally with a particular kind of machine, instrument or apparatus, with a number of machines, instruments or apparatus of the same heading, including machine, instrument or apparatus of headings 90, 10, etc., are to be classified with the machines, instruments or apparatus of that kind. And that is effectively the basis on which the upper tribunal found that the mastectomy bra was a part or accessory to the prosthesis, the breast form, and fell to be classified together with the breast form under 9021. And then finally, note 6, for the purpose of heading 9021, the expression orthopedic appliance means appliance for preventing or correcting bodily deformity or supporting or holding parts of the body following an illness, operation or injury. And it is the second indent of that which led the upper tribunal to hold that the mastectomy bra supports or holds a part of the body, being the artificial part of the body, the breast form, following an illness, operation or injury. And it is on the basis of that, on the basis of those two notes, effectively, that if we look at the actual heading at page 633, the upper tribunal classified the mastectomy bra as an accessory or part under 9021 3990, and this is at MS 634. And if I could start with the heading of 9021 at page 633, orthopaedic appliances including a number of examples, and other appliances which are worn or carried.
Excuse me,
Yes,
did you say 633?
I said MS 633, my lady, yes.
633?
MS 633.
About 2/3 of the way down to 9021.
Does that not...
Yes.
and you see...
Can you help me with this about that heading? It has semicolons dividing its various parts. So it's got orthopaedic appliances, including crutches, surgical belts and trusses. Well, we can all understand why those are orthopaedic appliances. Semicolon. Splints and other fracture appliances, which might also be regarded as having an orthopaedic function. Semicolon. Artificial parts of the body. Obviously, many artificial parts of the body don't have orthopaedic, aren't orthopaedic appliances. Hearing aids and other appliances, blah, 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 blah. Clearly, they're not orthopaedic appliances in any rational sense of the term. So this is covering a lot of things which are not necessarily orthopaedic appliances.
My lady, yes.
Does the definition of orthopaedic appliance to which you have just taken us apply to the whole of this heading, or only to that such of the heading as is genuinely an orthopaedic appliance?
My lady, by its definition, it only applies to orthopaedic appliance because that is what it defines.
So I think note 6 isn't of any particular help to us, is it? That also means it's not a hindrance either.
My lady, yes, hence my hesitation. It has always been treated, because
I know
the question
that's
hasn't
why I'm
been
asking
asked.
you the question.
It has always been treated as being applicable. But of course, note 6 expressly says the expression in inverted commas, orthopaedic appliances, which would suggest that, yes, it cannot either help or hinder, because it doesn't... What we're here talking about is not in that sense an orthopaedic appliance, but we're talking about another appliance to compensate for a defect or disability.
So which is the sort of governing definition for your purposes?
Well, my Lord, absent of a note, and the notes are of course, persuasive and useful tools, but not binding. Absent a note, all there is by way of guidance is what I've shown you. So it's 2B on accessories, and otherwise it is the wording of the respective headings. And as we will submit from the case law, it is clear that you look at, we say, the medical purpose behind behind the item, to work out whether
your case is that the artificial breast is an orthopaedic appliance within, on page, in the definition on 627, and so is the bra. Is that
my Lord, it is accepted that the breast form is an orthopaedic is an artificial part. I'm just trying to work this out. I apologise. It's an artificial part of the body, but it has been listed under 9021 3990, which is other, comes out as an artificial part of the body, because it's not an artificial joint. It's not an ocular prosthesis. So it is an other. But it is listed. It is listed there, and our case is, and this was upheld by the upper tribunal, that the mastectomy bra is an accessory to or part of that prosthesis, because one can't work with the other without the other, and or in itself is a
Basically, you look at the words other appliances which are worn or carried or implanted in the body to compensate for a defect or disability.
My lady, yes, and
that's the expression, and either it's part of that or it is.
My lady, yes.
It.
And our case is ultimately on the is it itself covered not as an accessory is that it is obviously an appliance worn to compensate for a defect or disability.
Yeah.
And that's ultimately on the facts, that where we say that the matter rests. And a large part of the debate in that context was ultimately, of course, focused on the point your ladyship has just annihilated, namely whether Note 6 applies and what it means, and whether it can cover an artificial part of the body as well as a natural part of the body, to which we would say, well, obviously, if it is meant to cover both, namely artificial parts of the body and natural parts of the body, the language chosen is not surprising.
But I mean, are you saying that really it doesn't matter for your purposes whether you're within Note 6 or not?
Yeah.
Ultimately, yes, my lord. In fact, not Note 6 not applying, we say, makes our case easier.
Yes. Well, if you're not saying if you're not arguing it's an orthopaedic appliance, then Note 6 is irrelevant.
My lord, yes. So there's perhaps one more provision in which I just briefly want to show your ladyship, your lordship. And this is at page, this is tab 2 of the volume of authorities. It starts at MS 640, and it's the explanatory notes to the combined nomenclature of the European Union. And it is at page 658. And you see there 9021 in the left-hand column. And these, as I said, explanatory notes published by the EU. For the purposes of this heading, the expression to compensate for a defect or disability means only appliances which actually take over or substitute for the function of the defective or disabled part of the body.
That would apply to the other appliances as well as the orthopaedic appliances.
That would apply to the other part. We can see that because the heading, of course, is in bold above, and yes, it would apply to that too. So
your reliance on the last words in 9021 can only bring you home if you can meet this EN criterion, appliances which actually take over or substitute for the function of the defective part of the body.
My Lord, subject to the fact that those notes aren't legally binding but persuasive, yeah, I accept that is the question. But of course, the upper tribunal found that it could, and therefore, in our respectful submission, the question was whether the Court of Appeal was right to think otherwise, or whether actually the decision to think otherwise was a disagreement on fact rather than a disagreement on law. And we'll look at that when we look at the Court of Appeal. Before doing that, can I perhaps try and set out what we understand the appropriate approach to all aspects of this appeal to be, by asking your ladyship, your lordship, to look at the most recent decision in the authorities, Oliver Medical, at volume 2, tab 22, page 1054. And your ladyship, your lordship will see that this is a classification case of the 10th Chamber of March 2015. It concerns Chapter 90, but not 92.1, but a different heading, and the question of their parts and accessories. It's a decision which we see in so many of these, done without an Advocate General's opinion, and it is one where I draw the Court's attention to the fact that Mr. Christopher Vida, the UK judge, was the rapporteur.
3 judges.
And it was 3 judges, so it's a small composition of a chamber rather than a... But again, my lady, one of the issues in this case is, in our respectful submission, is that the Court of Appeal placed a lot of emphasis on the findings, what we say are findings of fact, the Court of Justice made in some of the other cases, like Unomedical and Turban 1 and 2, all made by small chambers in a context where it's not the Court of Justice's role, we say, to make those findings of fact. It's the role of the Court of Justice to set out the principle and to give guidance to the national courts as to how these principles are to be interpreted, but then findings of fact to be made by the domestic courts. And we see that perhaps best expressed in this decision at page MS 1062, starting at paragraph 44. And we see that principle expressed there. It must be borne in mind as a preliminary point that when the court is requested to give a preliminary ruling on a matter of tariff classification, its task is to provide the national court with guidance on the criteria, the implementation of which will enable the latter to classify the products at issue correctly, rather than to classify the products at issue correctly, rather than to effect that classification itself. A fortiori, since the court does not necessarily have available to it all the information which is essential in that regard. And we then see, again, and we see this throughout the case, so this is a convenient point to take it, that the criteria at 45, legal interest, in the interest of legal certainty and ease of verification, the decisive criterion for the classification of goods for customs purposes is in general to be sought in their objective characteristics and properties as defined in the wording of the relevant heading and section and chapter notes. And then reference in 46 to the explanatory notes being an important aid but not having legally binding force. And then in 47, the intended use of a product may constitute an objective criterion for classification if it is inherent in the product, and that inherent character must be capable of being assessed on the basis of the product's objective characteristics and properties.
These are tremendously familiar words. I think they've been cut and pasted out of previous decisions.
My lady, that's why I said this is the latest reiteration of this. This is the language that flows through, which we say is, in a sense, is right. It's the court setting down what the principles are. But we then see, and this we don't see everywhere, in paragraph 50, it follows, therefore, firstly, that those appliances... Sorry, this is in paragraph 51, 48 through to 50 deal with the heading 91.8. But in 51, in order to establish whether a product is intended for medical use, it is appropriate to take account of all the relevant factors in the case, as set out in the order for reference, to the extent that they are characteristics and objective properties inherent to that product. It is for the importer at the time of import to prove that that product is intended for medical use. Among the relevant factors, it is necessary to assess the use for which the product is intended by the manufacturers and the methods and place of its use. And then we see that elaborated, and the distinction drawn between products which are intended for, or indications which are capable of establishing that a product is intended for medical use, and those which are not. And then the fact that the product bears a CE mark certifying the conformity of a medical device with the provisions of the Directive 93/42, that's the Medical Devices Directive, constitutes one factor among others to be taken into consideration in that regard. Nonetheless, since the directive pursues different objectives from those of the CN, and in order to maintain the coherence between the interpretation of the CN and that of the HS, the fact that a product bears a CE mark cannot be decisive as regards an assessment of whether it is intended for medical use within the meaning of that heading. Just pausing there, of course, you will have seen in the decisions below that references to the Medical Devices Directive were dismissed as being irrelevant, and my learned friend in his printed case makes the point that they are not decisive, and of course they're not. But what is clear from this, we say, is that classification under, or compliance with the Medical Devices Directive is a relevant factor in assessing whether something is intended for medical use. And of course, the mastectomy bra in this case is, and that's not in dispute, is compliant with the, or it is certified under the Medical Devices Directive.
But this is all addressing 901H, is that right?
My Lord, the issue arose under 91.8, but of course it is part of the larger heading 90, which we are concerned with. And it sets out some principles as to how you ascertain the intended use of the intended purpose of the product, so as to give it its appropriate classification. And then just to look at the...
So you say it could be medical apparatus under the big heading in Chapter 90?
Well, I'm not saying it is in general, it is within, we say it is within Chapter 90, and then the subheading 9021.
Yes.
But of course, as we will seek to show from the case law, looking at cases like Lohmann and others, what the case law is concerned with is to identify, and Europlasty is to identify whether these products have a medical purpose, namely to compensate for a defect or a disability. And we say that just as in the case of these products, the fact that they are recognised as having such purpose under the Medical Devices Directive, and in this case also in their VAT classification, while not decisive, is certainly relevant when one looks at whether the revenue has rightly classified these products for the purposes of the CA. Can I then just briefly look also at this for the purposes of Note 2 of Chapter 90, and that is the accessory and parts. And we see this at page 1064, MS 1064, paragraph 67. And we see second sentence, similarly under Note 2 of Chapter 90, parts and accessories are to be classified according to the rules laid down in that note, subject to the provision of Note 1. And then over the page, accordingly, it's appropriate to ascertain whether, in that case, the handpieces in question constitute parts or accessories. In that case, it is clear from the case law of the court concerning headings 8473, etc., of the CN that the notion of parts implies a whole for the operation of which the part is essential, and that the notion of accessory implies an interchangeable part designed to adapt a machine for a particular operation or to increase its range of operation or to perform a particular service relative to the main function of the machine. In order to ensure a consistent and uniform application, those definitions of the notions of parts and accessories apply as appropriate to the headings under, to those headings, and then also we see under 70 to the remainder of, we say, the remainder of the heading under Chapter 90. But again, we see a clear definition of what a part is. Namely, it implies a whole of a operation of which the part is essential. And if one takes a step back, again, looking at the evidence, the fact that the prosthesis and the breast form can't fulfill its purpose without the mastectomy bra and vice versa, in our respect for submission, clearly shows that they are parts of the whole, parts of a whole, and or that the mastectomy bra is an accessory to the breast form because it performs a particular service relative to the main function of the machine. And we had at the outset both the physical and the psychological aspects to the case, and they can only be fulfilled they are their main function. They can only be fulfilled if supported by a mastectomy bra. And then, of course, we see in 70, again, that it's for the referring court to establish whether the handpieces at issue are to be so classified. So that's the latest expression, certainly in the authorities before you, of the principles and of the test to be applied. Can I perhaps make one further preliminary point before I then want to take the court to the Court of Appeal's judgment itself? And that is really, again, to deal with the point which has been around throughout but these proceedings, but leads to a point of update which I need to make, and that is that certainly below there was always strong argument, or there was always an argument advanced by the revenue that our tribunals ought to decide in line with similar decisions or decisions on this product made by customs authorities in Ireland and the US and other states who had classified mastectomy bras as garments. But there are that, of course, was rejected by the first-tier tribunal and by the upper tribunal, and we can see from the case of intermodal transport, which, for your note, is at MS 971, paragraph 34 onwards, that such classifications are of limited, if of any relevance anyway. But secondly, and that is important, while to date the position has always been that the customs authorities of, I think, 2 or 3 other countries had so classified these products, largely on the basis that they were providing their support solely based on elasticity, a point that no longer is pursued. Since last week, there's now one decision of a court in another jurisdiction concerned with the CN, which is, of course, a worldwide convention, the Administrative Appeal Tribunal in Australia, which allowed my client's appeal against a similar decision there on the basis that the mastectomy bra is an accessory to an artificial part of the body, and as such cannot be classified as a garment. We have a copy of the decision here, but as it is a first instance decision of a tribunal in another jurisdiction, I'm not intending to make any submissions on it, but my learned friend has a copy, and I can make copies available to the court, because that is the latest state of play.
What's the reference for the how other countries have classified as of limited
That's
relevance?
intermodal transport, my lady. It's MS page 971. It's volume 2 of the authorities.
That's the beginning. It's
tab 20. Sorry, and then if I could ask your ladyship, 1024. And your ladyship, one looks at this case in more detail. The reference arose effectively out of a question, out of a situation where the authorities of another member state had given a certain classification to a vehicle, and the question was raised whether that affected or required the court seized in the stated issue in that case to make an order for reference to the ECJ. The question is at 1021. Question 1. Should the National Court refer questions on the interpretation of the CN to the Court of Justice where a party to a dispute brought before it concerning classifications issued in respect of a similar product, and the National Court takes the view that that BTI is at variance with the CN. And that's really dealt with at page 1024. Paragraphs 34 onwards. So we see at the end of 34, most certainly must cause that court to take particular care in its assessment of whether there is no reasonable doubt as to the correct application, taking into account in particular the three criteria cited in the preceding paragraph, which is, of course, the guidance given on the application of what was then Article 234 EC in relation to when a court is required to make a reference. And then at 35, on the other hand, contrary to the contentions of Intermodal and the Commission, and as the Netherlands and Austrian government have rightly claimed, the existence of such a BTI cannot in itself prevent the National Court from concluding, after an examination fulfilling the requirements noted in paragraphs 33 and 34, that the correct application in a given case of a CN tariff heading is so obvious as to leave no scope, particularly in light of the settled interpretive criteria identified by the court. And then we see the court at 36 through to 44 setting out all the reasons why divergent rulings, why divergent applications of the rules are not, certainly at that stage, fatal, and how they can be remedied. Culminating effectively at paragraph 44 onward, that proceedings could always be brought before the court on the basis of what was then Article 226 EC, which is direct action by the Commission on the basis of a failure to fulfil obligations. And if it's helpful for your note, the first-tier tribunal looked at the Irish and US authorities at paragraph 34 at MS page 137.
Well, I suppose paragraph 46 is of some relevance in this case, because it says that you don't have to refer.
Yes.
Well, if you disagree with any of them, you don't have to refer, my lady, yes.
Yeah.
And of course, our primary case being that the CJEU, certainly on the accessory and parts question, the CJEU has laid down the relevant criteria, and the upper tribunal has appropriately applied them. And insofar as the Court of Justice has applied them differently to the facts on certain cases, we would respectfully submit that as a matter of principle, that's not something the CJEU is entitled to do in any event, and therefore to ask them, would you classify the mastectomy bra as an appliance worn to compensate for a defect or disability, is not a question that is for which they have jurisdiction. And we'll see cases where that was made clear. Insofar as Note 6 was an issue until this morning, of course, there might have been a question. There might have been a question in relation to whether part of the body in the second indent of Note 6 covered an artificial part of the body. Could I then ask your ladyship, your lordship, to take up the Court of Appeal so that we can, for me to try and identify what we say were the error in relation to the accessory and parts issue. The Court of Appeal starts at MS 103 in Appendix 1. And we see that the consideration of this issue starts in Lady Justice Arden's judgment at page MS 111. Where we see references to Turban International in 28, and the question of whether a printer cartridge was a part or an accessory, part of or an accessory to a printer. And then we see in 29 the reference to the introduction late of Unomedical, which then made clear, as we see from the other judgments, that in fact the same test to accessories and parts as applied in Turban International to printer cartridges also applied as a matter of principle under heading 9021. And we then see at paragraph 34 the conclusions on issue 1. Lady Justice Arden setting out why she said, understandably, the upper tribunal reached the conclusion they reached on this issue, and there helpfully summarise or set out the upper tribunal's findings between paragraphs 56 and 61. And of course, importantly, we see, and bearing in mind what we've just looked at in Oliver Medical, the test they applied to accessory and part at the end of paragraph 57. In our view, an accessory is not merely something which is used in conjunction with an item. Accessory must also contribute something to the item. We consider that an accessory must provide some additional functionality or enhance the performance of the item. An accessory is an optional improvement to the product, whereas a part is something that is essential or integral to the functioning of the item. And just pausing there, we say that is an exact reflection of, or a near exact reflection of the test the Court of Justice has identified again in Oliver Medical. And in fact, there was nothing, there was no error of law in relation to the test they applied. They then conclude in paragraph 61, this is the upper tribunal. In our view, the mastectomy bra is part of or accessory to the breast form, in that the bra is used in conjunction with the breast form to enable both to function as a prosthesis for the natural breast that has been wholly or partly removed or reconstructed. The first-tier tribunal held at paragraph 32, the mastectomy bra cannot perform any corrective functions on its own without being used in conjunction with the breast form. Consider that finding to indicate that the bra is a part or accessory. We do not regard the fact that neither the bra nor the breast form would be a satisfactory prosthesis for the natural breast on their own, as meaning that the bra cannot be a part or accessory for use with the breast form. But
strange that they've put that in a negative sense. Must be responding to something in the argument. We do not regard the fact that neither the bra nor the breast form would be a satisfactory prosthesis as meaning that the bra cannot be a part. One might have put it in a more positive way.
Well, my lady, certainly, but your ladyship will see that and it's a submission made by my learned friend in this printed case. The argument for the revenue is that it's no more an accessory to the breast form than a normal bra is an accessory to the normal breast. And one can see why a tribunal might want to respond to that kind of argument in the way it did. Mm. So we then, the Court of Appeal, Lady Justice Arden, then goes on to rightly note, that the upper tribunal was not referred to Unomedical, but we say that ultimately matters not because they got the test right anyway. But if one then looks at 36 onwards of the conclusions of Lady Justice Arden, they all relate to, ultimately, findings of fact rather than, or disagreements of fact, or rather than application of principle, because the court looked at the definition of turban and then looked at the question in Unomedical whether the bags fitted to the dialysis machine, this is paragraph 38, could not be a part of the dialyser or catheter since they were not essential to the functioning of either instrument. Those appliances could function without a bag. The bags were also not accessories since they did not improve the performance or functionality of the dialyser or catheter. That, of course, misses out the other part of the text, or enable it to perform a particular service connected with its main function. And then it goes on to say the mastectomy bra is not a part of the breast form in the sense given in Unimedical, since it is not essential to the operation of the breast form. The breast form may be, and in some instances is, simply strapped to the body.
Well, in that event, are not the straps a part?
Well, my lord, our first point is that is inconsistent with the evidence that was found below. But also, my lord, yes, it confirms again that the breast form needs something to hold it in place.
Yes, the whole is the form plus the support.
My lord, yes, that was our submission, and we see, of course, the finding of the upper tribunal on the page before in their paragraph 61, that neither the bra that they just can't work without each other, and they're in a sense both parts of the same prosthesis in order to make it work, or to put in another way, the mastectomy bra, the bra is an accessory to the breast form in order to make it work and effective.
If it's essential to have something which attaches the breast form to the body and holds it up,
My lady.
keeps it in place,
My lady.
makes sure that it performs its intended function, does it matter whether there's more than one possible way of doing it?
Well, my lady, we would say not.
Well, it would be very surprising if it did matter,
My lady, yes.
provided it's essential.
My lady, yes. And of course we have here, and again, if one looks at the evidence, it's clear that these mastectomy bras, those sold separately, are designed specifically for this purpose and are used, that's what we keep referring to in our printed case and elsewhere as the market reality, are used almost exclusively by those who have breast forms. But they are in multiple form. One, because there are multiple, that they need to be carefully fitted to fit the needs of the individual. And in order to achieve their psychological effect, they need to be as close to a normal bra or regular bra as can be, so that the psychological impact isn't perpetuated by
I suspect it's producing an appearance
yes, my lady.
On a clothed body as being as close as possible to a body which still has all the normal mammary equipment,
My lady, yes.
basically.
My lady, yes. That's what I was,
That's
in
what
a
it
rather
means.
convoluted form, was getting at, yes.
An implication of this is that just say you had a part, or something that qualified as a part and was properly classified as such. If somebody else came up with an alternative design which would fulfill the same requirement, then neither of them, from that point onwards, could qualify as a part.
My lord, yes. My lord, yes. But of course, that also focuses on a part of the debate that certainly was had below, which is why there is the reference to the Lohman case about how do you distinguish between products with a medical purpose and those with a general purpose, because of course there was always the argument, well, either mastectomy bras could be worn by women who did not have an operation and didn't in that sense need to wear them, or vice versa, breast forms could be supported by an ordinary bra. But of course, again, that's why it is important to look at the purpose, the medical purpose of these products, which is clearly established by the evidence, which is there solely to support a breast form in order to enable it to achieve its effect as a recognised artificial part of the body. So that's, so just going back to the Court of Appeal, so we have there the upper tribunal, we say, clearly setting out the test as it is established also in Oliver Medical and the other case law. And insofar as the Court of Appeal was seeking to draw a comparison between the mastectomy bra and the waste bag attached to a dialysis machine as not being essential, one that is seeking to draw out of findings of fact made by the Court of Justice more than they can support. especially in a context where, as we see from Oliver Medical, it is not the Court of Justice's job to, in fact, make the classification as they did there. And secondly, of course, and your Ladyship, your Lordship's questions and my response to them hopefully indicate as much. Unlike that bag, which may have only been a waste bag at the end of the product, of course, the mastectomy bra is, we would say, essential to the functioning of the breast form. This difficulty with the guidance given by the court is even clearer when we look at the judgment of Lord Justice McComb at page 121, MS 121, where he sets out paragraph 86, turning to issue 1, however, I find this more difficult still. Common ground and agreed on all hands that the breast form itself is an artificial part of the body and would qualify. In general, accessories to parts included in Chapter 90 are to be included in the chapter. In any normal parlance, the mastectomy bra would surely be an accessory to the breast form. It holds it up. Certainly there was evidence that there were other means apart from mastectomy bras for securing breast forms, but in one way or another, something has to be done to prevent the form slipping, simply sliding down the body and out of place. The mastectomy bra is, therefore, in my view, as a matter of simple common sense, an accessory designed to perform an imperative function in relation to the breast form. And then goes on, is that the correct analysis under the CN, as interpreted in the cases? And he looks at the language and comes up with the answer yes, in relation to note 2b. And then in paragraph 89, he refers to the opinion of the Advocate General Cockott in Europlasty about the wide meaning to the word appliance, and then looks at the Oxford English Dictionary definition of accessory, and then in 91, as a matter of language alone, therefore, I would be inclined to hold the mastectomy bra as an accessory for an artificial body part, namely the breast form. Is this, however, compatible with the cases concerning the concept of accessory in the CN as decided by the CJEU? And then goes on to look at Turban and Unomedical, but starts it by saying, while a cursory internet search reveals many interests for printer ink cartridges onto printer accessories, the CJEU has held that such a cartridge is not an accessory to a printer, and then looks at Turban 1. Again, largely, we say, if one looks at the passage he quotes in paragraph 95, and 96, something which ultimately is the CJEU applying its guidance to the facts of a particular case and to perform the classification, which we submit is of course not its job. And we see in Turban in particular how flawed that process can be. And then comes in 97. For my part, I would have thought that the printer cartridge was classically something which performs a particular service relative to the main function of the printer, namely to enable it to print, but apparently not. And then looks at Unomedical, having thought that one could distinguish Turban on the basis that it didn't apply in the under 9021, and concludes ultimately, having again looked at the way the court applied that test to the waste bag, at paragraph 100, as might be understood from the above, I think that on any natural meaning of this word, it does precisely that. It holds it in place and it provides it sliding off the body, even if there may be other devices that are capable of achieving that result. Is that, though, enough for us to hold that the mastectomy bra is an accessory? Regrettably, I feel constrained to hold that the answer is no. But in our respectful submission, what the court there did, so perhaps to conclude, in 104, Lady Justice King, like Lord Justice McComb, would have thought that the printer cartridge was typically something which performs a particular service relating to the main function of the printer, namely to enable it to print. But we submit that what ultimately the court there did was not to identify an error of law in the upper tribunal, because the test, of course, is the test the court also applied in cases like Oliver Medical and others, but actually to take findings of fact made by the Court of Justice, to which the Court of Justice, with, as we will see in Turban, incomplete information, reached a particular classification conclusion, and elevate that to a legally binding principle or precedent, which prevented from giving the language in the CN the ordinary meaning, the ordinary meaning of the language.
Sorry, what are you saying about Turban 1 there? I mean,
Well, I'll turn to Turban 1 next, if I may. Turban 1, the court has at Volume 1, Tab 10, MS 693, and the judgment starts at page... perhaps I could ask your ladyship, your lordship, to just look at 693, because that conveniently summarizes in the first three paragraphs of the Advocate General's opinion the issue. These were specifically made printer cartridges for an Epson inkjet, stylus color inkjet printer, and which can only be used in inkjet printers of that make. And in paragraph 2, Turban, the cartridges argued that the cartridges fell under the heading 9473, parts and accessories suitable for use solely or principally with a machine, since they consisted of a part or accessory for a printer whose heading under 8471 is unchallenged. And then we have the question at the bottom of that page. The judgment starts at page 709, but the relevant consideration really starts at paragraph 29, page 723. And again, we have here paragraph 29, which was, of course, considered by Lord Justice McComb in paragraphs 94 and 95 of his judgment. It is apparent from the documents before the court that a cartridge such as that at issue is specifically designed for and can only be used by a particular type of printer. In view of that fact, the National Court wonders whether it's a part or accessory, and then in that connection it should be observed that the word part implies a whole for the operation of which the part is essential. And if I can just pause there, that is, of course, exactly the test the upper tribunal identified in paragraph 57 of its judgment.
And this again is a three-judge court.
This again is like my lady, like so many of them, is a I didn't check, but is a three-judge court.
709, if I'm right.
709, my lady, yes, with Judge Edward, Judge Pergola, and Judge Timmermans, yes. But for once with an Advocate General's opinion. But again, we see in paragraph 30, so the first half sentence, or the first sentence, really sets out the test. What is a part? And we say that is a test which the upper tribunal rightly identified. And then the court goes on, in our respectful submission, to apply that to the facts in a way that it is neither required nor, we would say, permitted to do. While it is true that without an ink cartridge, a printer is not able to carry out its intended function, the fact remains that the mechanical and electronic functioning of the printer in itself is not in any way dependent on such a cartridge. Inability of the printer, in the absence of an ink cartridge, to transcribe onto paper the work produced with the aid of a computer is caused by lack of ink rather than a malfunctioning of the printer. Again, pausing there, of course, one, we would say that's an assessment of fact rather than of law, but also, of course, if one uses that as a comparison to the breast form and the mastectomy bra, then the question doesn't really arise in the same way, because, of course, in that case, the dispute ultimately was about whether it is the cartridge or the ink in the cartridge which were the relevant dominant factor in the classification, which of course doesn't arise here because the mastectomy bra is not made up of composite elements, which may fall to be classified differently. And it is, as we saw from Lord Justice McComb, of course it is that the mastectomy, the breast form is not able to carry out its intended function without the mastectomy bra or another form of attaching it to the body.
I mean, the court seems to have been struggling to find a way of defining an accessory which didn't involve the consequence that, for example, petrol is regarded as an accessory to a motor car because it won't work without it. I'm not sure that it articulated the principle particularly clearly. As a matter of instinct, one sees there's a difference, but trying to describe it is almost impossible.
My Lord,
maybe one reason why examining case law about printers is not maybe a very helpful introduction to the status of mastectomy bras.
my Lord, that may well be right, and it may be that explains, at least in part, why they've tried to do it by fastening on to the facts of a particular case in order to try and to make that point. But one of the interesting things, if one looks at, and that's why Turban is so telling, if one looks at Turban 2... Do we get
any help from the Advocate General in Turban 1?
Not really, my Lord, no.
And I see in paragraph 50 on page 704 that the point is made, which is rather like my Lord Sumpter's made, that the essential character of the cartridge is the ink they contain.
Yes. My Lord, and that's, as I said, ultimately we see from Turban 2 that the ultimate dispute in Turban was then no longer about the relationship between the printer and the printer cartridge, but about the classification of the cartridge as an item which is made up of two composite elements, namely the cartridge and the ink within it. And there's a different note 3b, which I said doesn't apply here, which says if you have a product like that, you then classify by reference to what gives its defining characteristic. And the court ultimately came down and said it was the ink and not the cartridge. But just also with the car example, could I perhaps just ask your Lordship, your Ladyship, page 781, MS 781, is the Advocate General Cockott in Turban 2. And we see there, 64, that she says the cartridge is designed specially for the system, are essential for the operation. Do not have any other use. Without the cartridge, the printer, irrespective of the ink, the printer is unusable. And then we see at 67 Turban's argument that it would mean, for example, that if a car were designed such that if the fuel pump failed, the ignition would not start and the red light would light up inside, the fuel pump would not be a part of the car because the car would be functioning as programmed. And that is the closest we have in the case law to my Lord Sumption's analysis with the car. But the Advocate General says the correct approach is accordingly that the Peacock test means that the functioning of the whole for the operation of which the part must be essential is only the normal standard function of the whole. In the case of a car, this is driving, and in the case of a printer, it is printing. For that, a car needs a fuel pump, which is designed for its system, and a printer needs cartridges. And therefore we see, and we'll come back to that, she ultimately concludes that the cartridge is an accessory and therefore falls to be classified together with the printer. But the court disagrees, again, which shows up, in my respectful submission, why it is right that the Court of Justice isn't responsible for assessing the facts, because they are so sensitive and they are so can be so nuanced and views can differ. Here we have even the Advocate General and the court itself ultimately disagreeing. But what we
the way the Advocate General approaches the sort of petrol point is quite interesting. You know, she explains why the fuel pump in the car must be regarded as a part, but then she talks about consumables that that a machine uses, and in the case of a printer, obviously it's paper and ink. The analogy in a car would be petrol or diesel.
Yes. And there is some debate about refillable printer cartridges.
Yes.
But just briefly going back to Turbine 1, so we see at paragraph 31, page 74, we see at paragraph 31, the court therefore concluding that it can't be a part because it plays no particular role in the actual mechanical functioning of the printer. And then it goes on in 32 that a cartridge can also not be classified as an accessory of the printer because while they are interchangeable, they are not designed to adapt the printers for a particular operation or to perform a particular service relative to their main function or to increase their range of operations within the meaning of the HS explanatory note, merely enable the printer to fulfill their usual function, namely the transcription onto paper of work produced with the aid of a computer. One can see, in my respectful submission, why Lord Justice McComb found that logically challenging, how that is not to perform a particular service relative to their main function, namely to enable them to print. But it was on that basis, and even using this higher test of increasing their range of operations, again we said, actually the upper tribunal in paragraph 57 had that test right. And there was in that sense no error in law. And what persuaded the Court of Appeal to overturn the upper tribunal was the fact that the ECJ itself, on the facts of that case in Unimedical, ultimately came to a different conclusion. And if I could then ask you just briefly to look at Turbine 2, which starts at the Advocate General starts at 765, but we see, as I said, I've taken the court to 64 through to 68 and onwards, and we then see in paragraphs, page 782. We see her analysing the question of the ink at paragraph 72. And then in 74, thus as the ink cartridge consists of two elements, which when looked at separately may each be classified under only one heading, it is then important to look at General Rules 2 to 5. And importantly, for our purposes, is Rule 3b, which she looks at page 787. And she there comes to the conclusion, setting out again, and I emphasise again that this, of course, doesn't apply here, because we have not a single good consisting of different materials or made up of different components.
Yes, I mean, the distinction that's being drawn is between something that operates as part of the internal mechanical functioning of the equipment and something that simply enables the equipment to be of some use. The latter isn't good enough, the former is essential.
My Lord, yes.
But that distinction, you would say, you are on the right side of.
My Lord, yes. Exactly, my Lord. We would say that it is, even if one were to apply the test they applied, as the findings of fact show, this is essential to the working of the breastform. But we can see that the Advocate General then takes the view in 93, first judgment, the court assumed that the ink gave the ink cartridge their essential character. But then in 94 says, this assumption can no longer be maintained, having regard to the dual purpose of the cartridge, namely contain the ink and to form a functional unit of the printer. It is no longer possible to hold that the ink gives the whole of the ink cartridge its essential character, and she therefore jumps to Rule 3c at paragraph 99 and accordingly suggests that it should be classified with the printer as a part or accessory. But the court, in its judgment, doesn't engage with that engage with that debate at all, and finds at page 798, paragraph 17, again, setting out of paragraph 17 the now established test, namely word part implies a whole for whose operation the part is essential, and then just says, well, in the present case, the circumstances of the case communicated by the referring court reveal that the cartridge itself is necessary, and therefore it is a part, or is capable of being regarded as a part, but then goes on, and that, we say, of course, isn't relevant for our part of our argument, then goes on to look at Rule 3b, starting at paragraph 20, and without engaging with the Advocate General's arguments, concludes that, in fact, the ink is the most important factor, and therefore it still is to be classified as they previously said it was to be classified. But the reason we say that's the recognition there of the fact that the printer cartridge itself is a part is important, is one, because it highlights the difficulties the Court of Justice has in making these kind of actual classification, which is why it's not its role. And secondly, it shows that the cartridge, which is essential for the working of the printer, and it is a flawed comparison, is essential to make the printer work, just as we say the mastectomy bra is essential to make the prosthesis, the breast form, work.
So you said the whole is the breast form and the mastectomy bra, hence the mastectomy bra is part of the whole.
Yes, using that test, we would say the whole, of which there are two parts, is the mastectomy bra and the breast form.
Yes. In relation to accessory, using the definition there, an interchangeable part designed to adapt a machine for a particular operation or increase its range of operations or to perform a particular service relative to the main function of the machine.
Well,
what do you say there?
Well, we say the main function, but again, we say it's an accessory because it only enables the breast form to fulfill its main function, namely to compensate for the defect or disability. It provides a particular service to the breast form, if one can call it that.
The difficulty is that if that is the test, then the petrol is an accessory, and so is the ink, because it doesn't perform any useful function at all without it. So there's got to be something else in this distinction that the words that the court has used don't really quite convey.
Well, my Lord,
and the sole function of the printer is to print, and it can't do that without ink. So literally, those words lead to the opposite conclusion.
Oh, for that matter, it can't do it without paper.
Yes.
my Lord, my Lady, yes. But of course, that is... one of the difficulties I think the court is confronted with and we're confronted with is that the court hasn't articulated where it draws the line. What it has done is applied it in a way which is at times difficult to understand, on which even the Advocate General and the court itself ultimately disagree, whether, for example, the ink is so defining in the cartridge as to take it outside the part, as to take the whole thing out of the part or accessory aspect of the definition. But ultimately, going back to the decision of the upper tribunal, which is what the Court of Appeal was considering, of course, they in paragraph 57 applied a test for accessory as being something which is used in conjunction with an item, must also contribute something to it. We consider that an accessory must provide some additional functionality or enhance the performance of the item. It is an optional improvement to the product, whereas a part is something that is essential or integral.
Well, it can't be both a part and an accessory, clearly, on that approach.
Well,
an optional improvement, and that which one might see as being consistent with performing a particular service relative to the main function.
my Lord,
see that?
I accept that, and I have to accept that the upper tribunal ultimately refused to nail its colours to the mast or decide, and held that it was a part or accessory. But in my respectful submission, again, looking at why we're here, was there an error of law in the approach they took? And in my respectful submission, whichever way one looks at it, it is on the test we've seen, certainly a part, but if it weren't a part, we would respectfully submit it's an accessory.
Yeah, thank you. But it does seem to me that paragraph 57 is a much wider test than the definition of accessory laid down repeatedly by the CJEU, as, for example, in Unomedical in paragraph 29 and the various other passages that you've been referred to.
Well, let me just get Unomedical.
It's an interchangeable part designed to adapt a machine for a particular operation. You're not arguing that, or to increase its range of functions. You're not arguing that, or to perform a particular service relative to the main function of the machine. You are arguing that, I think.
Yes.
Yes.
Or you might argue increasing the range of functions compared with just strapping something on.
Well, it is strapping something on.
But my lady,
Yeah, without a bra.
Yes.
my lady, yes, in the sense that that's where the psychological element comes in my respect.
Yeah.
In that sense, that may well be right. That, of course, it isn't just strapping something on, but it is attaching an artificial body part in a way that makes the woman appear as whole as possible, without making it or avoiding any impression, or trying to avoid any impression of the defect or disability. Your Lordship, I'm very conscious of the time. You'll have in the bundle, we have made the more fundamental point about the division of roles between the domestic courts and the Court of Justice in terms of findings of fact. And we've identified 3 cases in the printed case. Perhaps I can just give them to you for reference, where the court makes absolutely clear in different contexts that it is not its role to make these assessments, but that is exclusively the role of the National Court. And the first case is a case called Fornasar, Volume 1, Tab 9, MS 673.
Where is this dealt with in your case?
This is dealt with in our case at...
Is this controversial at all, this section of your written case?
No,
Mr.
Lady, it's not controversial that the Court of Justice doesn't ordinarily make findings of fact.
Yeah.
Well, I will...
It's very fully set out in your case, but if it's not
my lady,
controversial...
it is. It's our item 1, the preliminary, and I'll just get the reference from what my Lord Carnworth. It's paragraph 17, 17 through to 27. And we have there also set out the cases, though largely in a footnote at paragraph 22 and then footnote 6. And of course, then we also have there the reference to this court's judgment in Amoena. Just briefly, there's in the alternative way in which we put the case, namely that the Court of Appeal was wrong, and this is paragraph 46 onwards of our printed case, was wrong to hold that the upper tribunal had erred in law in concluding that the mastectomy bra itself was not an orthopaedic appliance under 9021. And again, we see the finding of the upper tribunal at paragraph 69 of its decision, which is at MS 155. By number 30, we consider that whether applying the Advocate General's analysis in paragraph 66 to 69 of her opinion in Europlasty or note 6, the Carmen mastectomy bra is an orthopedic appliance because it performs the function of the missing muscles and tissue in supporting or holding the breast form or forms which are a part of the body following the mastectomy. Can I perhaps just briefly take you to uroplasty? This is volume 1, tab 13, MS 801. That's where it starts. And again, we see, helpfully, beginning of the opinion of Advocate General Cockott, the background. And then at the paragraphs the upper tribunal was referring to start at page 817. When we see in 58, the Advocate General considering they may be classified as other appliances which are implanted in the body to compensate for a defect. Of course, the ... in that quote are worn or carried, because, of course, in that case we were concerned with an implant rather than something that was worn or carried. It is unnecessary to decide whether they could also be classified as other orthopedic appliances. And then she goes through 59 through to 69, through a language analysis.
That's about what's meant by an appliance, isn't it?
That's what's meant by an appliance. And then looks at 69, concludes the use of macroplastic flakes is more closely connected to urology, which is concerned with urinary organs. This is not affected by the explanatory note 6. But she concludes at 68 that the modus operandi is more similar to that of a medicament than to that of an artificial body part. And she ultimately concludes, as we see over the page, that they were to be classified under 9021, 1990. And the wide definition used by the Advocate General was expressly endorsed by the court at paragraph 52, page 838. And if one takes that wide definition as a starting point and goes back to the guidance we looked at in Oliver Medical at paragraphs 51 to 53, we see there, again, the emphasis on the kind of medical purpose of the, in that case, implant. We also see that in Lohman, the case I think we referred to earlier, at tab 1, volume 1, tab 11, page 727, where, of course, the court was expressly concerned with the question of medical purpose, in particular in the context, as I said earlier, in the context of a situation where there were parts which did not have a medical purpose and those which did. And we say the important paragraphs are 29 to 31 at page 757. And we see that all sets out the test as we know it. And then we see in paragraph 39, the criteria for distinguishing simple or ordinary products from those serving a medical purpose therefore include a method of manufacture of the product concerned, the nature of the materials of which it is made, its adjustability to the handicaps which it is intended to correct, and other special characteristics, in particular its specificity of its purpose. And we then see over the page, setting out, in that context of orthopedic products, how that difference is to be ascertained, to conclude at 43 that if they display characteristics which distinguish them, in particular by the materials with which they're made, method of operation, or the adjustability to the patient's specific handicaps, from ordinary belts or supports for general use, in that respect, it's hardly relevant by whom and what time any such adjustment is made. So it's perfectly capable, we say, to cover within the definition of 9021. Let me just get it. Within the concept of appliances worn or carried to compensate for a defect or body, the mastectomy bra which has the relevant identifiable characteristics and the identifiable medical purpose as the classification on the Medical Devices Directive and its VAT treatment make clear, as the intention of the manufacturer makes clear, as identified by the First Tier Tribunal and the Upper Tribunal, as is made clear by the careful fitting process through trained fitters in order to make sure it fulfills its purpose. See our case at paragraph 4.6 and the SFI at paragraph 5.6 in the agreed facts, and the evidence of what we call the market reality as to the use of these mastectomy bras, which for your note, 3 examples of are in Appendix 2, MS 376, 378, and 599. And our respectful submission is that in the light of the focus of the case law on the medical purpose and the intended medical use, no reason was given other than Note 6, which of course only applies to orthopedic appliances, why a mastectomy bra should not be classified as an appliance worn or carried to compensate for a defect or disability, and certainly no reason why no reason for the Court of Appeal to decide that the Upper Tribunal, in so finding, had in fact committed an error of law which justified overturning the findings, clear findings of the Specialist Tribunal. My Lords, it is on that basis that we invite this Court to allow this appeal with costs. And
could you just deal with one point that puzzled me in the statement of facts, paragraph 4, where I'm quoted in Pendragon,
my Lord,
but in a way which doesn't seem to me to accord with what I was talking about.
My Lord, the quote in Pendragon, we have Pendragon here, is really...
I mean, I said that one should, where one's looking at where the Upper Tribunal has decided that the First Tribunal has gone wrong in law and has then made its own assessment of the facts and the whole thing. You should start by looking at that.
Well, as we read your Lordship's comments, I think agreed with by the other members of the Court, was that the Upper Tribunal itself is a specialist tribunal, and therefore the caution this Court and the appellate courts exercise in engaging with the specialist tribunals applies to the Upper Tribunal in the same way.
Well, that was what I was trying to say, but paragraph 4 suggests I was talking about something about how one should approach the merits of the Court of Appeal's reasoning, which I wasn't talking about at all.
No, my Lord, apart from I think trying to make clear that there's a distinction between the tribunals which are specialist and the appellate courts, which is the Court of Appeal and this Court, and that when we look at the Court of Appeal, the focus shouldn't be on did the Upper Tribunal engage with the First Tier Tribunal exercising a proper appellate function, but treating the Upper Tribunal as part of the specialist tribunals and therefore worthy of the same respect in the way one looks at them.
Anyway,
it doesn't take it any further than that. But it was to try and avoid any unnecessary jumping to and fro between the First Tier and the Upper Tribunal in this case, where of course the Upper Tribunal has accepted the findings of fact and did not see necessary to
I suspect that paragraph is not going to be crucial to the way in which this Court decides this particular case.
I suspect not, my lady. And unless I can assist the Court any further, and that's...
Any other questions? It appears not, Mr. Reiki. Thank you very much
I'm
indeed.
grateful, my lady.
Thank you. Mr. Brown? Mr. Singh.
My lady, my lords, Up until my learned friend's submissions this morning, we had understood his case to be that the mastectomy bra was a part of or accessory to the breast form, with the emphasis being on accessory, or in the alternative, that the mastectomy bra was an orthopaedic appliance. And indeed, when he defined the issues in paragraph 15 of his written case, he identified one of the two issues as being whether the mastectomy bra is an orthopaedic appliance. At paragraph 55 of his written case, he said that the Court of Appeal erred in rejecting the appellant's case that the mastectomy bra fell within the second indent of Note 6 to Chapter 90, which refers to supporting or holding parts of the body following an illness, operation or injury, because he said that that indent applied to artificial parts of the body. Now, it did appear from his submissions earlier today that he was no longer arguing that the mastectomy bra was an orthopaedic appliance. He agreed that Note 6 was not relevant, and he was arguing only that it fell within the other appliances subheading in heading 9021. But just as he completed his submissions now, he referred to the upper tribunal's decision at paragraph 69, in which the upper tribunal found that the mastectomy bra fell within the second indent of Note 6 to Chapter 90, which suggests that he may still be arguing that the mastectomy bra is an orthopaedic appliance.
Well, he was rather put on the spot, wasn't he, Mr. Singh?
Yes.
By my question, which he, on his feet, decided torpedoed Note 6. Maybe on reflection he might wonder about that, but I still maintain the fact that the heading 9021 covers things which can't be called orthopaedic appliances and includes the sort of residual category at the end,
Yes.
which is the one that most naturally deals with the product with which we're concerned.
Yes, you're completely right about the structure of the heading, milady, but it would just be helpful for my learned friend just to confirm whether or not he is still arguing that the mastectomy bra is an orthopaedic appliance, just so that I know whether I need to address you on that issue or not.
Well, perhaps, Mr. Riker, you could clarify. I appreciate that I've put you in some difficulty.
My lady, when I took you to paragraph 69, of course, paragraph 69 puts it on two bases. It puts it on uroplasty and on
Sorry, 69 of what?
69 of the upper tribunal, my
Upper
lord,
tribunal.
was the passage I took you to.
Yeah.
And that is at, if you bear with me, at 155. And there the tribunal put it in the alternative. So it put it on paragraph 66 to 69 of uroplasty, or Note 6. And it's never been part of the case against me that the case was always on both sides argued on the basis that it was an orthopaedic appliance, which might explain, at least in part, why the case was put the way it is. What we ultimately say is the upper tribunal was right to classify it under 9021. The Court of Appeal was wrong to find that it erred in law in so doing.
But I mean, are you saying that the breast form is a part of the body, which is what the basis of is being said at the last line of 69?
My lord, it is accepted that the breast form is an artificial part of the body. It is accepted by both sides that the breast form itself is an artificial part of the body. So even if one were to look at Note 6, which I haven't, but you have my written submissions on it if they were necessary. If it were within Note 6, we would say that Note 6 is perfectly capable of covering something that holds or supports not only a natural part of the body, but also an artificial part of the body. And there's nothing in the language of that second indent that says, that suggests otherwise. And while the Court of Appeal said, well, they would have said so if that was what it meant, in our respectful submission, the fact that it is capable of covering both natural and artificial body parts actually explains the economy of language by just saying holding a body part. And we say that could cover artificial body parts as well as natural body parts. So I don't think I'm giving quite the direct answer that my learned friend would quite like, but that is ultimately what...
Well, you want to have as many horses as possible to ride, don't you? You want to be either a part or an accessory or fall within the last part of 1921 or fall within orthopaedic appliance on the basis of holding up
my lady,
part of the body. You'd like to have all of those things for
my
us
lady,
to think about.
in fairness, I wouldn't quite have put it like that, but yes, because ultimately the situation, or our position, is that when the CN was drawn up, mastectomy bras are not classified clearly in either category, and they are, by definition, vague terms which need to be dealt with by analogy quite frequently. And there is very little guidance on how they are to be applied. And that is how, even after arguing it now for the fourth time, we still find questions which none of us had thought of before, which lead us down yet another avenue, which is why I put it as broadly as I have, my lady.
I mean, I understand you're wanting to run as many horses as possible, but which is your front runner?
It's our job to decide. You're entitled to suggest that it's our job to answer that question.
I apologise.
If you're unable to help me, then we leave it to us. But I think after having, as you say, argued this 4 times over, one would have thought you would have a view as which the front runner is.
Well, I tell you what, why don't you answer that after we've heard from Mr. Singh?
I will, my lady. I'm very grateful.
Could I just clarify one point while you're on your feet?
Yes, my lord.
You're founding on paragraph 69 in the upper tribunal judgment. But if in the last sentence of Article 69 one deleted the word orthopaedic and just said an appliance, then that finding that it performed the function of the missing muscles and tissue is necessary to meet the relevant explanatory note on 9021, whether it's an orthopaedic appliance or another appliance.
My lord, yes.
You'd accept that?
Yes.
Yes, thank you.
I see, I mean, I don't want to add to the confusion, but I see in the Europlasty opinion by Advocate General Cocotte, at paragraph 58, which is on MS 817, she...
Page, it says?
817.
817. Thank you.
Paragraph 58, she says that it's unnecessary to decide whether they could be classified, the flakes could be classified as other, quotes, other orthopedic appliances. Well, in fact, as far as I can see,
that word doesn't exist.
That phrase doesn't exist. So she seems to be reading the words that do exist, other appliances, as meaning other orthopedic appliances. Well, may I assist you on that?
Yeah.
Under the wording of heading 9021 that applied at this time, there was a subheading of other orthopedic appliances.
Fine.
Yes.
Thank you.
But that isn't there anymore.
Right. Fine. Thank you.
Thank you. Thank you.
Yes.
This is it.
Yes, so, my lords, in light of what the learned friend has just said, I think I will make some submissions on orthopaedic appliance, just to be on the safe side. But what I propose to do is begin by making submissions on the part or accessory issue. Now, there are 3 relevant Court of Justice authorities, Turbon 1, Turbon 2, and Medical. May I just take you back to Turbon 1, first of all, which is in the Authorities Bundle, Volume 1, behind tab 10. And may I take you straight to the court's judgment, which begins at MS 710. And you can see that in paragraph 1, The question was on the interpretation of headings 3215 and 8473. At paragraph 2, we see that the question arose in proceedings concerning the tariff classification of ink cartridges without an integrated print head for use in Epson stylus colour inkjet printers, ESC printers. If we have a look just over the page at paragraph 4, we can see the competing headings. So we have 3215, printing ink, and at the very bottom of that page, 3215, 90, 80, other. So that was one of the subheadings that was claimed to apply. And then if we have a look over the page, MS 712, we have 84, 71, 60, 40 printers. Below that, 84, 73 parts and accessories. You see what that says. And then just over the page, 84, 73, 30, 90, other. Now, the German customs authorities and the Commission argued that the ink cartridge in issue was to be classified as ink under heading 3215, whereas Turbon argued that the cartridge was a part or accessory of a printer under heading 8473. If we then have a look at paragraph 12 of the court's judgment, we have an indication as to what is meant by accessory. And the court takes this, at paragraph 12, from the harmonised system explanatory note relating to heading 8473. And when we look at UNO Medical, we'll see that this definition applies to Chapter 90. So finally, according to the HS explanatory note relating to heading 8473, the accessories covered by this heading are interchangeable parts or devices designed to adapt a machine for a particular operation or to perform a particular service relative to the main function of the machine or to increase its range of operations. We can see that the parties' main arguments are summarised at paragraphs 15 and 16. You may just want to quickly read those to yourselves. At paragraph 20, we see the question referred. And again, you may just want to briefly read that to yourselves. And the key findings of the court are at paragraphs 27 and 29 to 32. My learned friend read out paragraphs 29 to 32, and I would just ask you to have a quick look at those again.
Yes.
And when my learned friend took you to paragraph 30, in which the court sets out what the word part means, referring to the case of Peacock, he said that the upper tribunal applied this test at paragraph 57. Now, in my submission, it did not do that. In paragraph 57, the upper tribunal was considering what accessory meant rather than what part meant. And my learned friend then said, when he took you to paragraph 32, which sets out what accessory means, he said, well, the upper tribunal applied this test in paragraph 57. And again, in my submission, it did not. And one only needs to read paragraph 57 of the upper tribunal's decision to see that. Now, this was a case, Turbon 1, where the ink cartridge was specially designed solely for use with a particular type of printer. And without the cartridge, the printer could not carry out its intended functions. So it would not be able to produce anything other than blank paper. But for the Court of Justice, that was insufficient to make the cartridge a part, because the printer would still mechanically function. So in other words, the printer would still operate even though it would not produce anything of any use. And according to the Court of Justice, the cartridge was not an accessory within the meaning of heading 8473, because all it did was merely enable the printer to fulfill its usual function, which was to print onto paper the work typed out on a computer.
Well, what it's getting at, surely, is a distinction between the internal operation of the machine and the material which it is designed to process. A printer is designed to process ink and paper.
Yes.
The ink and paper are not accessories to its internal functioning. The fact that the printer will do nothing useful to man or beast without both ink or paper, therefore, is irrelevant.
Yes.
This is a problem about machines that are designed to process some external material like petrol, ink, paper, and so on, which appears to have no real relevance to the particular issue with which we're concerned here.
Well, my Lord, I submit it is relevant, because what we see from Turbon 1, Turbon 2 and UNO Medical is a test emerging. In Turbon 1, in my submission, in deciding the part or accessory issue, what was important to the Court of Justice was plainly not, as my Lord Sumption has indicated, whether the printer would in practice be used with the cartridge, because as a matter of common sense, it would always be used with the cartridge. Rather, the key factor for the Court of Justice was whether the printer was capable of functioning without the cartridge, even if, in practice, it would never be used in such a way.
Well, I'm not sure that can be the whole test. I don't think that my formulation depended at all on what would happen in practice. There are surely two tests to be satisfied for an accessory. One, it's got to be essential to enable the printer to work. Well, the ink might be said to satisfy that test. And two, it's got to be part of the operation of the machine rather than part of the material upon which the machine operates. And the latter test was also not satisfied in the Turbon case, but it's irrelevant to our case.
Yes, but, my Lord, when one considers whether something is necessary for, let's say, the main item to work, it's clear from Turbon 1, and then when we look at Turbon 2 and UNO Medical, that it doesn't actually have to work in any sense that is useful to anyone. In UNO Medical, the court was concerned with dialyser drainage bags and attached to a dialyser, and urine drainage bags attached to a catheter. Now, in practice, no one would use a dialyser without a drainage bag. No one would use a catheter without a urine drainage bag. But that wasn't sufficient for the Court of Justice to find that the drainage bags were parts or accessories of the machines. And what I say...
It didn't satisfy the first those tests, does it enable the machine to work?
Yes.
And in the unimedical case, the second part of my formulated test, namely, is it part of the machine or part of the material which the machine processes, didn't arise.
Yes, but the way the court approaches the issue in kind of the three cases that we have is that what we do know is that, and this is relevant in this case because my learned friend focuses on what happens in practice with the mastectomy bra and the breast form, and what we do know from the three decisions is that for the Court of Appeal it is irrelevant whether in practice the main item would be used without the claimed part or accessory.
But it's not, I mean, in this case,
yes.
the point being made is not that that in practice people would use it in conjunction with the breast form. The point is that the breast form can't function at all unless something is done to keep it in place. And this is a method of keeping it in place. And so unless it's a sufficient basis for your case to say another method could have been chosen, it doesn't seem plausible, then that's the real essence of the case made against you, isn't it?
Yeah, well, my lord, we say that I will come on to this, another method could have been chosen.
Yes, but do you also submit that the fact that another method could have been devised to keep it in place is fatal to either of them being an accessory?
Yes, because my lord,
that seems a rather ambitious submission.
Well, my lord, we say there's support for it in Turbon 2. So may I take you to Turbon 2 now? Because we saw the Court of Justice revise its view on what was a part in that case, on the basis that the word that the Court of Justice used was the printer would be dead without the ink cartridge. So that's how extreme the test is. I mean, may I just take you to Turbon 2 so we can see how the court reached a kind of different conclusion on part. So that's behind tab 12 of the authorities bundle. And may I take you to the court's judgment, which begins at MS 790. Paragraph 10. Paragraph 10, it is apparent from the decision of the referring court that following that judgment, this is Turbon 1, Turbon International challenged before the referring court that part of the Court of Justice's reasoning set out in paragraph 30, according to which the mechanical and electronic functioning of the printer is not dependent on the presence of an ink cartridge, such as that at issue in the main proceedings. Turbon maintains that such a premise is factually inaccurate and that the court wrongly inferred from this that an ink cartridge, such as that at issue in the main proceedings, cannot be regarded as part of a printer. 11, whilst hearing the evidence at the hearing, the referring court was given a demonstration of how the printer operated. Paragraph 12, according to that court, that demonstration confirmed the statements of Turbon International, namely that when connected to a computer, a printer which contains no or only one cartridge does not respond to the print command issued from that computer. In that situation, data are not transferred from the computer to the printer, and the print head does not move from side to side, nor is any paper drawn into the printer. The printer is, as it were, dead. And then paragraph 13, the referring court adds that if, on the other hand, the cartridges are inserted in the printer, irrespective of whether they are full or empty, the printer initializes itself as soon as they have been inserted. That is to say, it executes an internal mechanical process, etc. And you can see the rest of that. But you may just want to have a look at paragraph 14.
Well, they're explaining, aren't they, why what I call the first test
Yes.
Was satisfied in this case. Without the printer, you couldn't actually make the thing work at all. But they then go on to distinguish the ink on the footing that what that demonstrates is that the second test, is this part of the machine or is it the material on which the machine operates, was not satisfied.
But, my lord, what they would decide that is relevant is that the ink cartridge is capable of being a part. They find that that test is met. But on the facts of this case, they decided that the essential character of the cartridge was the ink. But they did decide that the test was met.
Yes, but I mean, they also decided that the ink was not an accessory.
Well, they didn't make a finding on accessory, my lord. If we have a look at...
It must be implicit in that the ink itself is not an accessory.
Well,
you therefore ask why not?
my lord, what we see from their decision, if you go to paragraph 17, we can see that they refer to the same case on the meaning of part that was referred to in paragraph 30 of Turbon 1, namely Peacock. And then at paragraph 18, in the present case, the circumstances of the case communicated by the referring court revealed that the cartridge itself is necessary for the printer to function, as in, without the cartridge, a printer would be dead.
Yes.
It is therefore capable of being regarded as a part. They don't go on to consider accessory. So the part test is met in this case.
I mean, if you have a car with an empty tank, petrol
Yes.
tank, it's dead. But nobody would suggest that the petrol was an accessory, or a part for that matter.
Well,
I mean,
yes.
the trouble is one can analyse the language of these cases in great detail. What one actually needs to identify is what is the concept with which they are grappling, because to my mind at any rate, the language they've used to describe it is not actually very helpful, but the concept can be identified even so.
Yes. Well, my lord, one important point to make just in response to what my learned friend says is that in reaching the finding that the cartridge was capable of being a part, the court did not question the strict approach taken in Turbon 1 deciding whether a product was a part, and indeed it referred to the same case on the meaning of part, namely Peacock. And, my lord, I say what's really the important point to draw out of this judgment is that what the court decided on the revised facts was that without the cartridge, as I said, the printer would be dead. So the printer would not be capable of functioning in any sense without the cartridge. So before it wasn't capable of functioning in any useful sense. Now it wasn't capable of functioning at all. So the cartridge met the strict test for part that applied. Now what the court did not do is what my learned friend says it did at paragraph 34 of his written case, and I may just read that out to you. It's MS 74. What he says the Court of Justice did, he says, paragraph 34, the CJEU therefore had in fact in Turbon 2 corrected its analysis in Turbon 1 and contrary to the finding of the majority of the Court of Appeal had restored the natural meaning to the construction of the terms part and accessory under the combined nomenclature. Now, the court did not even consider the term accessory in Turbon 2, as we've seen, only part, and it did not restore the natural meaning, whatever that is, to the term part. Rather, it did not demur from the strict approach taken to the meaning of that term in Turbon 1. And what we see is that strict approach is applied by the court subsequently to Turbon 2 in the case of Uno Medical. Now, my learned friend didn't take you to this particular case, but it is important to look at. It is in volume 2 of the authorities bundle, behind tab 15, and it's an illustration of how strictly or how narrowly the court wishes to define the concepts of part and accessory. So tab 15, authorities volume 2. And we also get an indication from this case as to what the court means by accessory as well as part. So if we just have a look at the 859, see the products at the very top in the summary refer to plastic dialysis drainage bags intended exclusively for use with dialysis, plastic urine drainage bags intended exclusively for use with catheters. The competing headings 9018 and 3926. And then if you just go on to look at paragraph 6, this refers to heading 3926, other articles of plastics. And then what we see in paragraph 7 is the court states it follows from note 2R to chapter 39 that this chapter does not cover articles of chapter 9. So that's similar to the way the notes in chapter 62 are worded, and it doesn't cover articles of chapter 90. We can see in paragraph 8 what chapter 90 deals with, and then paragraph 9 we see the competing other heading, and 90, we see the title of heading 9018 given. If you look just below that, 9018.20.00, it refers to catheters. And then if we turn over the page, 9018.90.30 refers to artificial kidneys or dialysis. And then what we see in paragraph 10, the court states the notes in chapter 90 contain, and then we see that the similar provisions, those my learned friend took you to earlier, parts and accessories, the references to parts and accessories there in 2A and 2B. Then we have some discussion of the harmonised system explanatory note, which concerns accessories, and it's referred to at paragraph 13. The facts of this case are quite important. Paragraph 15, according to the National Court, the urine drainage bags for catheters are bags with a capacity of 2 litres intended for bedridden patients. We can see, just skipping the next sentence, the bags are designed to function together with a standard balloon catheter, but are imported and sold without the catheter. And if we look at paragraph 17, the National Court states that the drainage bags for dialysis are hemodialysis bags specially designed to fit a dialyser, the purpose of which is cleansing the patient's blood and so on. These plastic bags, which have a capacity of 2 litres, serve to collect the excess liquid filtered by the dialyser. When in use, dialysis bags hang on a hook at the bottom of the dialyser and are fitted with a piece of tubing which ends in a connector used to connect them to the dialyser. Paragraph 18, dialysers are, as a general rule, equipped with a mechanism which electronically prevents dialysis from starting up or proceeding if there is a break in the closed system in the form of leaking joints or air in cannulae. In the same way, dialysers are designed to stop and sound an alarm if dialysis bags are full or are not correctly attached. Now, you may just want to read paragraphs 19 to 23.
Well, they said that aspect of the functionality was not relevant because essentially it was a security element which was irrelevant to the normal functioning of the machine.
Yes.
I mean, it's a very narrow definition of the concept of accessory, but it appears to depend on the alleged accessory being parts of the intended functionality of the machine, so that when they refer in paragraph 17 to the object of the machine being to cleanse the patient's blood and remove excess fluid from the body, those are functions to which the bag does not contribute. It simply collects the resultant waste.
Yes. But I mean, that is correct. But when one considers what the dialysis drainage bag, for example, is for, it is, we see that it's specially designed to fit the dialyser. It's intended exclusively for use with and can only be used with the dialyser. And as you indicate, my lord, the dialyser would stop and sound an alarm, albeit that's
but the
security.
The actual test
Yes.
that's applying is this part of the intent, the normal functionality of the machine itself? not
Yes.
whether it is desirable or even essential to have one as well, but whether it's part of the functionality of the machine.
Yes, well, the test, the reason in Medical that the court said that the drainage bag for the dialyser was not an accessory was because it did not enable the dialyser to perform operations other than that for which it was designed.
Exactly.
That was a reason. Can I just refer you to a few more paragraphs as for your note? So paragraphs 19 to 23 just set out the dispute between the parties. And then the key findings of the court are paragraphs 29 to 38. And what we see the court doing in 29 to 38 is importing the notion of accessories, which is referred to in the harmonised system explanatory note to heading 8473, into chapter 90. Yes. And then they set out their reasons as to why the drainage bags in the case are not parts or accessories. Yeah, so, Lady Laws, we say this is an illustration of how narrowly the court wishes to define the concepts of part and accessory. They cannot even apply. Something cannot even be a part or accessory in cases like this, where you have dialysis drainage bag, specially designed to fit a dialyser, intended exclusively for use with and can only be used with the dialyser. Given that the purpose of the bag is to collect excess bodily fluids removed by the dialyser, highly improbable that anyone is going to use the dialyser without attaching the bag, even if that were possible. The urine drainage bags are intended exclusively for use with and can only be used with catheters. And they're used by bedridden patients. And again, it is very difficult to envisage them being used without drainage bags, as otherwise there will be no container for urine to drain into. But nevertheless, the court finds that neither of these bags is indispensable to the functioning of the dialyser or catheter. And that is because the dialyser and catheter would still function in the sense that the dialyser would still cleanse blood and the catheter would still drain urine present in the bladder. And we say that that is really a stark illustration of the strict approach the Court of Justice takes to the question of whether an item is a part or an accessory. To the court, what happens in practice is irrelevant. Rather, the court looks at whether the main item, be it a printer, dialyser, catheter, or dare I say it, bra, is capable of, I say that is the test, it looks at whether it's capable of functioning without the claimed part or accessory, regardless of whether it would in practice be used without the claimed part or accessory.
So I don't quite understand that.
Yes, sorry, Lord.
The artificial breast can't function without the bra to support it.
Well, it can't function. We'll see what the evidence on that is in a moment. But it can function without the Carmen mastectomy bra. in my submission.
Well, yeah, I mean,
Yes.
but that's a different point.
Yes.
Here, we can see at the top of page 868, that the point they're making is that the drainage bag has the sole purpose of collecting liquid after the catheter has fulfilled its own function, which is to drain the urine present in the bladder. So it's sort of
Yes.
a sequential approach, which, I mean, whether that's right or wrong in that context, it simply doesn't apply here, because whatever the mastectomy bra does, it does it at the same time as the part. So,
Yes, but
so I mean, they're there together.
yes, but we say
So
that
this seems to me have no relevance to that, other than just showing that there's a fairly narrow approach adopted.
But it is relevant in this sense, because we say what the court is getting at is whether the main item is capable of working, even in the sense of no use to anyone, without the claimed part or without the claimed part. Now, the claimed part or accessory here is a mastectomy bra, so one has to consider whether the breast form can be held in place without the common mastectomy bra. We say it should be.
That's really the key point in your argument. You say that it's not enough that the function performed by the alleged accessory is essential. You also have to show that it's essential to do it in this particular way and not by, for example, a simple strap or an adhesive. Now, that is the submission that I perhaps prematurely described as ambitious a while ago, but it is actually the key to your whole case, isn't it?
Yes, my lord, it is. It is. Yes, whether if the breast form can be attached with adhesive or in another mastectomy bra or with a normal bra.
Or another mastectomy bra. So the mere fact that there are different designs for mastectomy bras, all of which have precisely the same functionality, is enough to deprive any of them as the status of accessories. Is that right?
Yes, my lord. Yes, we say, but the fact there are other mastectomy bras is not the only factor here.
Well, other mastectomy bras of a somewhat different design,
Yes,
but with the same functionality.
Yes, but there was evidence in this case that there was an adhesive strip system that worked with a number of breast forms, and it could be the breast form could be attached to the thorax wall that way. I was just going to give you the notes for this. But what we say is that applying. So if we just take part first of all, and then look at accessory. Just on the case law, incidentally, we would say my learned friend hasn't really pushed his request for a preliminary ruling, but what we say is that a preliminary ruling is not necessary because there is nothing unclear about the decisions in Turbon 1, Turbon 2, or Medical. They are very clear in formulating this very strict approach and narrow and setting out what is or narrowly defining the concept of part and accessory. Now, what the court has said is that the notion of parts implies a whole for the operation of which the part is essential, and we saw that referred to in all three cases. Now, my learned friend has not suggested that the mastectomy bra, the particular one we're concerned with, the common mastectomy bra, is part of a particular breast form. We know from the evidence that the appellant alone has more than 150 different shapes and sizes of breast form. And for your note, that's MS 435, paragraph 22 of Ms. Seahouse's statement.
The note we looked at earlier, note 2, 2B and C, do distinguish between parts and accessories which are suitable for use solely or principally for a particular kind of apparatus, on the one hand, and all other parts and accessories.
Yes. I'm not saying this is fatal to the appellant's case, but what I say is that it must mean that my learned friend's case is that the mastectomy bra is a part or accessory to breast forms generally. Because he hasn't identified a particular breast form. And indeed, my understanding is that breast forms can be adapted and so on, and put into whatever bra is suitable for the individual person. Now, as we've seen, the Court of Justice has approached the question of whether an item is a part in Turbon 1, Turbon 2 and Medical, part of a main item, by considering first what the function of the main item is. And we saw the court do that with the printer and then with the dialyser and the catheter. Lady Justice Arden, in her judgment below at paragraph 40, said that the function of a breast form was to simulate the appearance of the natural body. And we don't have any qualms with that as a formulation of the function of the breast form. Now,
But what about if you accept simulate the appearance of a natural body?
yes.
Is it not the combination of the bra and the breast form which comes closest to simulating the appearance of the natural body, the ordinary body with an ordinary bra? Isn't that the whole purpose?
Well, milady, it's the combination of something which holds the breast form in place.
No, it's more than that, isn't it?
Well,
Just strapping the thing on is not going to come anywhere. And then imagine a T-shirt on top.
right, but
Everything a T-shirt test.
well, you say that, milady, but when we look at the evidence that the First-Tier Tribunal considered, it may be worth just bringing this up now, bringing up the First-Tier Tribunal's decision, which is MS, the relevant paragraph is at MS 132 in the core volume.
The MS number again, sorry.
Yes, it's 132, my lord. And it's paragraph 24, and it's about 7 or 8 lines down, just above 40 in paragraph 24, in an abstract written by Dr. Munstead. Dr. Munstead was one of the people who provided a witness statement in this case. W. Milch and C. Reimer, it was concluded that after mastectomy restoration of body symmetry, a very important aspect of coping with daily life may be achieved either using breast forms that are suspended in a brassiere or by a new system in which breast forms are attached by adhesive strips to the thorax wall. The system promises free and easy movement, favourable effects on lymphedema, and improvements with respect to dressing. Brassieres are not necessarily needed. The influence of improved prosthetics on patients' self-concept and well-being was investigated. A group of 67 patients after unilateral mastectomy tested custom breast forms and self-adhesive breast forms. Most patients were better satisfied with epicutaneous self-adhesive breast forms. And the reference in the bundle for that abstract is MS 391. That's in part 2 of the appendix. So, milady, it's not necessarily the case that a mastectomy bra in conjunction with the breast form would be the best way of simulating the appearance of...
And there were aspects of Dr. Munstead's opinion that the tribunal rejected.
Yes.
In paragraph 26.
Yes, exactly, milady.
So they weren't tremendously impressed by that.
No. So, in order to carry out its function, the breast form needs to be located in the chest area. Now, as we've seen, the evidence indicates that a breast form can be attached by adhesive strips, and that's actually not a very unsatisfactory way of doing it. Now, for those breast forms which cannot be attached with adhesive strips, I am not suggesting that they're going to routinely be used with normal brassieres. The evidence was that those breast forms which cannot be attached with adhesive strips will virtually always be used with mastectomy bras. That was the evidence. Not necessarily the Carmen mastectomy bra. They could be used with other mastectomy bras. And finally, on this point, there was no evidence before the First-Tier Tribunal that a breast form was incapable of being suspended in a normal bra, if that's a correct term to use. For your note, a statement was produced on behalf of the appellant from Jackie Benzakri, who was involved with the cancer charity. It's at MS 376. It's in Appendix Part 2. the FTT referred to her statement at paragraph 26 of its decision, and what Ms. Benzekri said was that an ordinary bra is usually unsuitable for use with an external prosthesis. It was not suggested in the appellant's evidence that the ordinary bra was impossible to use with an external prosthesis. So in my submission, if a breast form can be attached using adhesive strips or can be suspended in other mastectomy bras or a normal bra, the Court of Appeal was right to find, on the basis of the strict Court of Justice case law, that the Carmen mastectomy bra was not a part of any breast form.
Or an accessory.
Well, I'm just coming on to that now, my lord, that as we've seen, the Court of Justice has held that the notion of accessories implies an interchangeable part designed to adapt a machine for a particular operation or to increase its range of operations or to perform a particular service relative to the main function of the machine. In Turbon 1, the ink cartridge was not an accessory because it merely enabled the printer to fulfill its usual function of transcribing onto paper work produced with the aid of a computer. In Uno Medical, a drainage bag for a dialyser was not an accessory because it did not enable the dialyser to perform operations other than that for which it was designed. Applying the Court of Justice's approach, the use of the Carmen mastectomy bra is merely one way of enabling the breast form to fulfill its usual function of simulating the appearance of the natural body. The Carmen mastectomy bra does not enable the breast form to perform any operation other than that for which the breast form was designed.
Suppose that there's only one way of doing it, of holding the breast form up, and that's with the Carmen bra.
Yes.
And it's therefore classified as an accessory. Now, let's suppose that a year later somebody invents another way of doing it. Does it follow from your submission that immediately you have to reclassify the Carmen bra as not being an accessory because somebody's invented a different way of doing it?
Well, my lord, if there's only one way of doing it, in my submission it's more likely to fall within the concept of part rather than accessory.
But would that cease to be the case if a year later somebody invented a different way of doing it?
Well, yes, my lord, I would say yes.
Equally, if there were a patent for a device and the patent expired.
I'm sorry, my lord?
If there were a patent for a device,
Yes.
a device which qualified, on the expiry of the patent, other manufacturers might enter the market with similar devices,
Yes.
and presumably it would no longer qualify.
Yes, because then the main item the main item is capable of functioning without the without the claimed part. I mean, before the other item was introduced, it wasn't. Before the other item it was introduced, it wasn't. But after the patent expires and a new item is brought into circulation, it is. So then I say it no longer meets a strict Court of Justice test. And we do also say that Lady Justice Arden was right in what she said
So
about...
can I just be clear, I understand it. You are conceding or accepting that if you have one way of doing the thing, which results in it being properly classified as an accessory, and a year later... Correctly classified as a part. I see.
Yes.
Yes,
Yes.
And a year later...
That's important because it's the word is essential. That's
Yes.
what you're founding on.
Yes.
It's the whole for the operation of which the part is essential.
Yes.
So you weren't in that discussion. You weren't in fact discussing accessory at all.
No.
No.
Yes.
So it's simply part. And someone invents another one a year later, it's no longer essential, so you reclassify.
Yeah, certainly in the context of this arrangement, where you have a breast form and a mastectomy bra, if it was ever the position that there was only one, it turned out there was only one way of holding up the breast form couldn't actually do anything, so it would be dead without that one mechanism of holding it up, then what one can envisage, without preempting the customs classification authorities in a future hypothetical case, one could envisage that being treated as a part. But then if something else comes out in the market, then the main item is not dead. The breast form will not then be dead without the initial part, because it can be affixed in some other way.
No.
So a car part,
I'm sorry, milady.
a car part is no longer a part of a car, even though it's essential. Something like that is essential to the operation of the car if there's more than one brand.
Well, milady, this is not about brands. We're not dealing with brands here. That with the
design.
sorry,
More than one design with
Yes.
the same functionality.
Yes, milady.
Wheels.
May I just turn my back
Tyres.
for a moment and check this with my instructing client? So,
Yes, tyres are a good example, aren't they?
all right. So what my instructions client indicated was that the customs classification authority would always look at the objective characteristics of the product. I mean, if we're dealing with brand, if we're just dealing with different brand, but the objective characteristics are the same, then perhaps in that situation it wouldn't actually make a difference. But the scenario we have here is that we have things where the objective characteristics are different to some extent. So if a breast form has some self-adhesive function to it, that is different to the suspension mechanism through a bra. So we say there is a difference there. But it is difficult to discuss hypothetical situations because it all does depend on the particular facts. And on these facts, we say the bra cannot be a part, can't be an accessory item.
You make a corresponding submission in relation to accessory.
Well, accessory is slightly different because that is about whether the so-called accessory gives the main item any additional functionality. Well, it's not about that actually. It's more about does it enable it to perform an operation other than that for which it is designed. And in the scenario we have,
It's somewhat wider than that, isn't it? It could be or to perform a particular service relative to the main function.
yes, but that again can't be something which the main item is designed to do anyway.
But if the answer to that question is yes, it is designed to enable it to perform a particular service, do you say that isn't good enough because there are other ways in which that result can be achieved?
No, my lord, because the tests are different for part and accessory, yes, because the whole part is the whole for which the part is essential, and accessory is a different test according to the Court of Justice. Yes, just one moment, sorry. Okay, so unless I can assist you further, those are my submissions on part or accessory. I just have submissions to make on orthopaedic appliance and other appliances, but perhaps I could do that after the short...
Could I ask you to, I'd like to look a bit more carefully at the phrase, perform a particular service relative to the main function of the machine, but we can do that after lunch.
Look at it a bit more carefully.
Yes.
Yes.
Thank you.
and consider how it applies in other...
Yes, I want to understand why you say that the product in question here doesn't perform that service.
Yes.
Thank you.
We look forward to hearing your answer to that question at 2 o'clock.
Yes, ma'am.
We'll adjourn now.